We are going to discuss forum nonconvenience. This is a method that is employed to stay proceedings when there is no mandatory law available in the forum, or the parties have failed to reach a jurisdiction agreement. This is a doctrine that is primarily focused with the appropriateness of the chosen forum by the plaintiff. The English Spiliata case held that the test for determining forum nonconvenience was whether there is a more appropriate forum that is connected to the dispute. To determine this, we look at three factors: the availability of witnesses, the party's place of business, and the law of the cause. If those point to a different jurisdiction, the plaintiff can resist the challenge by showing that they will be unable to rely on a legitimate judicial advantage that is currently available to them in this forum. The Australian approach to forum nonconvenience was first enunciated in Oceanic Sunline Shipping and Fay, and in that case the respondent had purchased a ticket to go on a cruise in Greece, and on the back of that ticket it stated that any action brought against the carrier needed to be brought in an Athens court. Whilst on the cruise, a shotgun exploded, severely injuring the respondent, who decided to bring proceedings in the Supreme Court of New South Wales. The issue was whether Spiliata should be followed to determine forum nonconvenience. Ultimately, the Spiliata test was rejected, although Justices Wilson and Toohey in dissent applied the test. Justice Brennan chose the traditional approach, which focused on whether it was vexatious and oppressive to bring the action, and Justice Dean and Gaudron took an intermediate position and applied a test about whether it was an inappropriate forum for the case to be heard, and this was explored in Voth and Manilta Flour Mills. In that case, a company incorporated in New South Wales was the plaintiff, and the defendant was an accountant in Missouri. It was alleged that that defendant had provided negligent advice to a subsidiary of the plaintiff in Kansas. So then, could proceedings be stayed on forum nonconvenience grounds? It was held that the Australian court was a clearly inappropriate forum, which is very rare for an Australian court to hold. They had modified the doctrine of forum nonconvenience and said that an Australian court will only decline jurisdiction if proceedings are vexatious, and oppressive, or an abusive process. And proceedings will be vexatious and oppressive if the local court is deemed a clearly inappropriate forum. To determine whether a forum is clearly inappropriate, we examine the same factors that were presented in Spiliata, and we also add in the second limb of that test about whether there is any legitimate, personal, or judicial advantage available in the current forum. So then, the difference between Spiliata and Voth is that Spiliata tells us that we need to look for a more appropriate forum. However, in Voth, we need to look inwards at our current chosen forum and whether it is inappropriate based on those factors. An example comes from Dow Jones and Gutnick, where Dow Jones had alleged that United States law should apply to the dispute, and that because of this, it would make the Supreme Court of Victoria a forum nonconvenience. However, it was ultimately held that the Supreme Court of Victoria would not be a forum nonconvenience for the mere fact that it was required to apply foreign law to the dispute. So in summary, in Australia, the Voth test applies, however the relevant factors are those from Spiliata, and the mere fact that a court is required to apply foreign law will not make it a forum nonconvenience.